Ladies and gentlemen, if there's a person who has never heard about Lord Denning, then I would question, especially if you're a lawyer or a law student or an advocate, they will probably question what law school you went to. Lord Denning wrote a book called Freedom Under the Law. That was in 1949. And it remains a pivotal examination of the balance between individual liberties and the state power. And it demonstrates how society sometimes thrives, and it creates thematic analysis in terms of the applications of the law. But I would like to argue them in terms of the contemporary law as we know it today. Some of the core themes and arguments that he proponed had to do with the rule of law. For example, Lord Denning emphasized that freedom is maintained under the rule of law, and a cornerstone for democracy. He asserted that the law must act as a check on the arbitral power and ensuring that government actions are actually subject to legal scrutiny. And he famously argued that be ye never so high, the law is above you. And those are some of the things that we need to comprehend today. In terms of relevancy, you could argue in terms of judicial review, for example, in terms of modern democracies which uphold Denning's principle in terms of a thorough judicial review, where courts check executive averages. Cases like R versus what Miller, Prince Minister versus the one of the UK case, it creates those those dispensations in terms of that. You could also argue in terms of anti-corruption measures, where Denning's advocacy for unchecked power supports global anti-corruption frameworks and even mechanisms that have to do with enforcing accountability, such as Uganda's Anti-Corruption Act and institutions like the Inspectorate of Government. These are some of I'm trying to play it down in terms of how these would work or go well in terms of Uganda. You could argue also in terms of the protection of individual rights. Yeah, Denning highlighted that the law must be a safeguard in terms of individual freedoms, such as the freedom of speech, assembly, and even a right to what they call a fair trial in terms of the dispensation of justice. You could also argue by way of application that he also argued in terms of what they call the freedom of speech, especially in terms of legal frameworks. In terms of Uganda's case, for example, our constitution, Article 29 particularly, embodies what Denning emphasized in terms of protecting the freedoms of expression, and challenges even the misuse of anti-terrorism laws, for example, dictatorial restrictions, for example, that require costs to balance activity and security and even rights. And things to do with fair trial. Lord Denning also emphasized on what they call procedural fairness in terms of the relevance of ensuring justice for all, especially under the law addressing terrorism and even sedition, for example, which sometimes compromise the legal process itself. And in terms of the independence of the judiciary, Denning also underscored the importance of the judiciary in terms of being free from executive influence. You may want to look at my book, Demystifying the Executive Mandate, where I argue that the instances where the judiciary, the judiciary becomes more executive-minded than even the executive itself. You need to look at that book where we bring out some of those components. And you could also argue in terms of contemporary impact. Judicial independence, for example, in Africa, countries like Kenya and Uganda strive for what they call judicial independence in terms of, in the face of political pressure. So the role for judges like Uganda's judicial, lawyer or systems, we have to emphasize the aspect of fairness in terms of protecting our constitutional right. In terms of, security of tenure, for example, the struggle between executive influence and even the judiciary's, autonomy remains recurring as an issue. And that is something that Lord Denning also emphasized during his time, which actually plays out very well even as we speak today. If you argue in terms of what they call landmark cases, that will probably illustrate some of the things that I'm talking about, you could maybe want to point out and say that Lord Denning's reflections are actually, enriched by case law that actually illustrates some of his philosophy. I would argue in terms of what they call Intique versus Carrington, which is a 1765 case, where he reiterates that the principle that no one, including the state, can actually interfere with individual property without legal authority. And the case informs modern, privacy rights in terms of against unlawful surveillance, for example. You could look at Riverage versus Anderson, which is 1942. So although Lord Denning was actually not involved, his criticism in this particular case in later writings, where he actually, deferred to the executive power in terms of wartime, for example, resonates with contemporary debates in terms of state power and even the emergence of including responses to terrorism and even other pandemics. You could also argue in terms of freedom under the law, in terms of the dictator age, Lord Denning could have actually predicted the rise of technology, but his principles do apply nonetheless. And you could argue that, for example, privacy and even surveillance, modern laws like, let's take an example for UK's Investigatory Powers Act of 2016, or even Uganda's Regulation of Interception of Communication Act of 2010. All these things test Lord Denning's idea in terms of the legal challenges that actually question the very essence of surveillance in terms of freedoms, as it were. And then the freedom of expression and also social media. Legal frameworks struggle to balance freedom and regulations in terms of hate speech, for example, online. Denning's advocacy in terms of protecting speech, except where it actually harms others, offers a philosophical guide in terms of that dispensation as well. You could also argue in terms of what they call economic freedom and social justice, for example. Lord Denning's reflection on property rights and even economic freedom rights has a need for equity in terms of resource distribution, for example. And these are substantially important because they do, augur well with our situation today, even as we live in today's world. In terms of application, you could argue that land, for example, and resource rights, in terms of dispute, for example, over land ownership, in terms of resource management, for example, particularly in Africa, where historical injustices intersect with modern development, resonate with Lord Denning's emphasis of justice and even fairness. And his approach to equity in terms of common law becomes extremely important in terms of appreciating these economic imbalances as well. You could also argue in terms of Lord Denning's legacy and criticism. Lord Denning's brilliance in terms of writing and even judicial reasoning, for example, and a lot of admiration. And he faced a lot of criticism for some views, particularly concerning social equality and even the aspect of race, which was common during the time, understandably so. And you could also argue, if you argue in terms of bias and equity, or equality for that purpose, his remarks, for example, in Sawyer versus AG, which was a 1980 case, sparked debate about his stance on race. In today's judicial system, it emphasized anti-discrimination in terms of rectifying those historical imbalances. And that's something you may want to pick out as a lacuna. In terms of, for example, a reflection, I would argue and say that Lord Denning's freedom under law, particularly because that's the book I'm talking about, provides redress in terms of highlighting some of those safeguards against these aspects of digital surveillance and global security threats. And the book serves as a profound reminder of the principles that underpin democratic governance. If you're to argue for purposes of takeaways, then you may want to look at checks on powers in terms of courts, which must remain vigilant and even against what they call the erosion of freedoms. That is substantially important in terms of arguing that. You could also argue as a takeaway in terms of what they call judicial courage. Judges must be independent. They must be bold. They must follow Lord Denning's example in terms of that application. I was at the High Court and I saw Lord Denning's picture right over there. I hope they'll comprehend and understand some of this applicability in terms of what judicial precedents he presented before us. In terms of balancing security and liberty, in terms of policymakers, for example, ensuring the address of modern threats without actually, compromising fundamental human rights. And if you could argue in terms of takeaways that resonate so deeply for those of you who like his writings, or perhaps who like making submissions that are related to some of these giants of the law of the times then, you could argue in terms of the rule on the law. When he argued in terms on the rule of the law, he said, be you ever so high, the law is actually above you. In a sense, he was actually saying the court escalates the fundamental principle that no one, regardless of the statute or power, is above the law. It emphasized accountability in terms of governance and justice, and that is fundamentally important in terms of comprehending that. In terms of on justice and fairness, he argued and said the best judge on whether a thing is right or wrong, or just or unjust, is not what the government says. It's neither parliament. It's what the ordinary man thinks justice requires. His aspect here was Lord Denning, trusted the common sense and the moral intuition of the ordinary people in terms of understanding the justices and in terms of reminding the importance of the public of the conscious in the law, and that is some kind of Ubuntu, if you like, and that's fundamentally important. In terms of judicial courage, Lord Denning emphasized that a judge must not alter the law to suit his own personal wishes. He actually must apply it as he finds it. It's even though it's very repugnant to his own end, it's important that he actually does exercise and should actually apply it boldly without any apology. So the reflection was in the sense that judicial adaptability, balancing the respect for the law with a progressive approach in terms of how it should be applied. And in terms of freedom, freedom does not mean being free to do as you like, but being free to do as you ought. And by this, his emphasis was distinguishing between freedom as what? As a license, and freedom as a responsible exercise of right, underlining the ethical foundations of liberty. And in terms of perhaps arguments in terms of what they call legal reasoning, where predominantly he actually asserted himself, his argument was that the house of the law has many mansions and there are many rooms in it. We have common law, we have equity, we got state law, we got international law, and each must be given its due. And in terms of importance, you could argue and say the complexity of the legal system and the need to harmonize between the different principles and the doctrines becomes fundamentally important. And then in terms of equity becomes fundamentally important. Who doesn't know? Equity came to aid the rigorous of the law. Not so. So you could argue that equity varies with the length of the chancellor's fact. That was something that was said by Lord Denning. But in essence, he was actually saying that the classic expression of the flexible nature of equity, acknowledging that the discretion in terms of applying equitable principles can actually vary, even though it must be guided by fairness. Another aspect of Ubuntu Law, not so. You may want to read a book called Ubuntu and the Law. And then you could also, in terms of the role of judges, his argument here was that a judge should not be a servant of the government, but a servant of justice. And that is fundamentally important. And this stresses the independence of the judiciary as a cornerstone of a fair legal system. Then you could argue in terms of the pursuit of justice. The law, in its sense, he argued that the law is not an end in itself. It's a means to end, and that end is fundamentally justice. And therefore, the argument here is that the ultimate purpose of the law is serving justice rather than rigidly following the procedures of or precedent. Maybe you want to look at my book, Freedom Through the Law, as well, which makes that proposition. So these, basically, in terms of what Lord Denning are sharp intellect and even passion of justice, enduring influence in terms of legal philosophy, and in terms of how these things do apply to us. So Ledding's work, in terms of his period of probably 7 years plus, continue as a beacon of justice in terms of the dynamic legal landscapes that we enjoy in this country today. Once again, my name is Isaac Christopher Lubogo. Find many of our books. We've got about 80 now running at lubogo.org and suegenesislawup.com. Once again, thank you for your attention and God bless you.